So now I'd like to introduce our guest presenters this morning. So our first will be Naté Dearden, who happens to be my supervisor. And Naté is the Student and Family Rights Coordinator at the Utah State Board of Education, where she leads a team of amazing specialists who are engaged in supporting work related to special education dispute resolution, equity, education and mentoring services for youth in custody, and family engagement. Naté's past professional experiences include work as a Families First specialist for Utah Youth Village, providing legal assistance to parents experiencing difficulty accessing special education services for their children in Chicago, and collaborating with community stakeholders to improve post-secondary outcomes for students with disabilities in Washington, D.C. Naté holds a BS in Family and Human Development from Utah State University and a JD from the J. Reuben Clark Law School at Brigham Young University. After Naté, we will be hearing from Jackie Chamberlain, and she is the Public Information Officer for the Utah Division of Juvenile Justice Services. Previously, she served as the State Education Liaison for the Department of Human Services. Prior to this, Jackie worked in the Virgin Islands as a photojournalist, was a lead reporter and editor, writing and editing classified reports for the Utah Counter Drug Program. She also served as an adjunct facility for the Utah National Guard and the NSA, where she taught English and reporting. She received her BA in English from the University of Utah and an MED from Weber State. With Jackie, April Graham will be presenting, and she is the Program Director of the Office for Community Programs within the within Utah's Division of Juvenile Justice Services, overseeing case management and parole transition teams. Overseeing case management, parole teams, and transition teams, female residential programs, day skill intervention, and partnering with community and private providers. Ooh, lots of P's today. She has over 22 years of experience with Juvenile Justice Services. April holds a master's degree from University of Utah in social work and is a licensed clinical social worker. Sorry, I am so tongue twisted this morning, and apparently one of my dogs wants to have a say in what we're doing this morning. All right, with that, I also wanted to share that, like I said, the USBE team will be presenting as we wrap up today, and I think you know all of us by now, Julia Armstrong, Nick Schelleberger, and myself. Okay, and with that, let me stop sharing because I will want to turn the screen over to Miss Naté. All right, so Naté, if you want to turn on your camera and mic, we're ready to roll. There she is. Hello.
Thanks, Amanda. And did you give me co-host so I could?
Let me do that. I did not.
So I can screen share. No worries.
All right, you are good to go.
Perfect. Oh, let me do this. I use double monitors, but sometimes when I present, it doesn't work. So
I agree.
Detach and stick to one thing here. Okay. Okay, well, I'm excited to be with everybody today. I have been hearing about how awesome all of these webinars are that Amanda's been arranging and doing and that you guys have been participating in. And I just am sad that I'm not able to be in all of them in person, but I just hear about the great work you do, and we all have a shared passion, I think, for helping students who struggle and who need that extra support and attention. So I'm excited to be with you. What I'm hoping today is to finish up around like 10 to, I'm like telling myself how to do time, 9:50 or 10 o'clock, and then we'll have a little bit of time for questions. But if you have questions that pop up while we're going along, please stick them in the chat box, and I'll have Amanda help me monitor the chat if that's okay, Amanda. And you can let me know if I'm on the slide and need to clarify something.
Absolutely.
Thanks. My presentation style is to always over prepare. So I'll share these slides with Amanda. I kind of got them done at the last minute, so I didn't give them to her ahead of time. But I know I won't get to everything. So I've tried to front load some of the things that came from questions that you all submitted. And so I've included some links and some things that I hope can be resources. All that said, if you have questions, particularly about special ed law moving forward, never hesitate to reach out to me because I'm happy to help. And that's what I actually spend a lot of my day doing anyway. And I much rather help people find the answers than have you searching or feeling like you don't have the tools to know what to do. So I wanted to include just a little statement from, this comes from the Individuals with Disabilities Education Act preamble. And I just think it's a beautiful way to set up the purpose of this federal law. It says disability is a natural part of the human experience and in no way diminishes the right of individuals to participate in or contribute to society. Improving educational results for children with disabilities is an essential element of our national policy of ensuring equality of opportunity, full participation, independent living, and economic self-sufficiency for individuals with disabilities. And I think you all play a key role in this coming to pass. So I like to remind people about the end goal of why we do special education, and it is so students can be independent as much as possible and that they can access just community living and become economically self-sufficient. When I did a lot of policy work in DC, my practice area was really with those high school students and looking at what they were going to do life after high school. And we spent a lot of time looking at statistics, and it was very sobering to see that many adults with disabilities live below the poverty line and do not have gainful employment. And so that became kind of a shift in my understanding that many folks with disabilities can work, but they need these skills that they develop through their educational experience and volunteer and internship experiences to help them get to that point. I also wanted to share something that Salt Lake School District created in the past year or so. They called it their Inclusion Manifesto. And I bolded some of my favorite parts, but I think a key part is something we preach all the time. We believe that all students are general education students first. And we say that because in our practice, sometimes we have seen that within a school environment, general education folks or other folks within the school don't really think of students with disabilities as theirs or ours. And so we understand that truly including kids and helping them starts with that inclusive mindset. And that's why I love this phrasing at the end that says, we believe the attitude matters and that the achievement of all students depends on our belief in their competence. That's a key belief in the disability rights movement, is presuming competence rather than the alternative. And so it's been my experience in 10 years of working with our students with IEPs and with disabilities that if we believe they can be successful and we start from that inclusive mindset, we can be creative, we can find solutions much easier than if we have kind of a limiting mindset as professionals that are supporting them. I wanted to just give you a little bit of a timeline. For me, history is important. Understanding where we came from helps me understand where we need to go now. And so what I like folks to understand is kind of the door for civil rights for students with disabilities really came about with Brown versus the Board of Education. We have a Supreme Court case that basically states separate is not equal. For parents of kids with disabilities, they saw that point that, as you see under this 1972 bullet, when Congress did an investigation prior to creating the IDEA, they found in the country there were about 8 million kids who required special ed, and only about half of those were receiving services in a public setting. Some kids were in segregated settings and institutions, and then there were 1.75 million children who were not in school. And that was often connected to state laws that prevented kids with certain disabilities or certain IQs from even accessing the public education system. So that investigation, along with some of these key cases in big cities and states that I've noted, those kind of pushed Congress toward creating this law. And I share this with you in part because even today, we still run into times where when a student has challenging behaviors or is having challenges making progress academically, it is sometimes a professional mindset of segregating them and pushing them out of the general ed setting. And although the law requires us to provide a continuum of placements, meaning students can receive supports in different settings, we always want to push for that least restrictive environment if possible, because we came from a history where kids were pushed out and segregated, and the point of this law is to help us not do that. So I'm sure many of you have kind of heard some of these terms flying around, but when we talk about individual education programs or IEPs, we also often talk about FAPE. And FAPE just stands for Free Appropriate Public Education. And what that means is that it's standards aligned with the grade that the student is in, and the age corresponds, their age corresponds with the grade that they're in. We have an IEP that guides that way that we're providing FAPE, and it's a free service that's available to kids ages 3 to 21. If a student graduates with a diploma prior to 21, then services end, but some of our students with disabilities will continue to access services through their 21st birthday. There was a Supreme Court case a couple years ago that looked at what FAPE means. And I didn't want to bore you guys because I know many of us don't read Supreme Court cases for fun. So I pulled out some bullets for you to look at. And this is a little text heavy, so don't get overwhelmed or just refer to it later. But some key points of this case were that the IEP needs to be tailored to meet the needs of the way that the court phrased it is they said it should be reasonably calculated to enable the child to make academic progress appropriate in light of the child's circumstances. They also talked about how their programs should be appropriately ambitious and they should have the chance to meet challenging objectives. That said, they said an IEP doesn't guarantee any particular level of education and it doesn't promise any outcome other than we want to see students make progress, but we don't guarantee diplomas, we don't guarantee all A's, things like that. The reason I wanted to share this with you is because you know your students extremely well, I think, as you work with them over time. And I think you're an amazing part of the team to help the team understand the children's circumstances and help give an idea of what you think is appropriately ambitious or challenging for the student. You guys are doing progress monitoring, you're keeping a close eye on students, and so you may be the first one who could kind of join with the IEP team to determine if a student's making progress or not. And so I can definitely see how you could play a role in ensuring that the school is providing a FAPE to our students' abilities. I wanted you to be aware that there's a few other laws that kind of come into play with these situations. Some of you may be working with kiddos who have a 504 plan. And I always get questions, what's the difference between a 504 and an IEP? And so I'll give you the short answer, but I'm going to link you to a resource that has a really good chart right here, if you click on the link that I put on the image, it will take you to a full-blown chart that goes through a lot of different things. And so I'd encourage you to visit that if you have questions, because this is a question that comes up a lot. But the way I describe it is there are two different federal laws. The IDEA is an education law, and it's something people call an entitlement law, meaning it gives students something. It gives them education services for free. The 504, Section 504 of the Rehabilitation Act, it's an anti-discrimination law. And so its goal is to prevent discrimination and retaliation. And that is why they're a little different. The IDEA comes with funding that comes to schools and states. Section 504 doesn't come with funding, but it says if you receive any government funds, you have to give individuals with disabilities access to your programs through providing accommodations. So often the distinction between the two is we have some students who need some accommodations, but they don't need special ed services. And our kiddos with the IEP under the IDEA, they need both. They need that more extensive instructional support versus Section 504 that kids just maybe need some of those accommodations. The other law that comes into play is FERPA, which maybe you've heard of. It's the Family Educational Rights and Privacy Act. And Amanda did give me some questions from your group that kind of had questions about when can I see the IEP? What part of the IEP could I see? Kind of that idea of accessing a student's IEP so that you could support them in the work that you're doing. And it gets a little confusing, but that actually falls under FERPA, not IDEA, because FERPA governs all student records and information. And this just happens to be a student record or information about the student. So as you may know, FERPA, it gives parents these rights that they can access things, that they can review information, etc. But there is a piece of the law that I pulled out to share with you. Typically speaking, if a school shares information with others, they have to get parent consent before doing so. But there are exceptions to that. And this is a little wordy, but the key takeaway I tried to put in the title, it's legitimate educational interest. And so if you see in this section A, it says an educational agency may disclose personally identifiable information if the disclosure meets one or more of the following conditions. And the very first condition is the disclosure is to other school officials, including teachers within the agency or institution, that the agency or institution has determined to have a legitimate educational interest. The next line down talks about contractors, consultants, volunteers, or others that the school has outsourced services to. So it's my interpretation that you fall within this exception. You are a school official as an employee of the school district, providing check and connect mentoring services to these students. And so as such, I would argue that in many cases, you have a legitimate educational interest in seeing elements of the students' records. You're already looking at some of their records. And so there is misunderstanding in the field about this law. And there are times where I go into train in a school and the school hasn't shared the IEP with anybody but the special ed teacher. And they're like, well, FERPA doesn't allow it. And I'm like, no, that's not what FERPA says. So I think sometimes people tend to rely on something they are not completely understanding. We do have a student data privacy team here at the USBE that can offer training, but I'm happy to reply to questions too. So what I'd say is some of the questions you submitted are like, how much can I see or what can I see? I mean, I think given the work that you do, being able to see the IEP would be very helpful for you. And so please work with your supports, your supervisors or others to get access, but if you're experiencing difficulty, please reach out because I think it's helpful for you to have access to this information. So one of the other questions that came up had to do with parents, and I think it is tricky because many of our students involved with youth in custody, this is a little bit of a murky issue. It's not always as clearly, we're not always able to clearly identify who might be a parent under the IDEA. And so I want to specify what I'm going to share next. It is directly connected to the IDEA. There are other elements of who a parent is that come up in different scenarios, but what I'm talking about is who would serve as the parent on the IEP team and who the IEP team would be required to give notice to and get consent from in the process. So I've given you the definitions from the rules, and it's wordy, and I'm sorry. But what I would say is I don't even have this memorized. When questions come up, I pull it up because there's a lot of options. But I'm going to teach you a couple of tricks. So this first bullet goes through all the different folks who could be considered a parent to a student in terms of the IDEA. And you'll see it's kind of extensive, but it starts with a parent means biological or adoptive parent. You'll also see a little bit further down, an adult with power of attorney or other legal authority to make educational decisions, or a surrogate parent. We're going to talk about that in a moment. This comes up a lot for me with youth in custody. It also comes up a lot for me in situations of kiddos with divorced parents. And there are some divorce decrees that are clear about who's the education decision maker, and there are some that are not, that are vague. So this second bullet is a key thing. The biological or adoptive parent, when attempting to act as the parent, and when more than one party is qualified to act, must be presumed to be the parent unless the parent does not have legal authority to make educational decisions for the student. And lastly, if a judicial decree identifies a specific person or persons to act as the parent, then that person is the parent. So I just encountered this a lot with our youth in custody, that there's some confusion abounding. And so I think it's important to help the school to look at what legal documents we have. Can we identify who is the person who has those decision-making rights? And especially with some of our students in foster care, their biological parent may still have some rights, they may not. It just is very case specific. But we know that a lot of our kiddos have foster parents. And so there is a specific section in the definition that talks about when a foster parent may be the parent. And so I've seen this happen a lot too, but it basically revolves around the biological parent's authority has been extinguished. The foster parent has an ongoing long-term relationship with the student. They're willing to be the education decision maker, and they don't have interests that would conflict with the interests of the student. So that may come up occasionally with you all as well. But, oh, dang it. I think I skipped. Here we go. There is a chance with some of our students that we may not be able to identify anybody who fits within any of those options that I just listed. And so I wanted you to be aware that the LEA or the district has to make sure that a student has somebody who is a parent. And so in some of those cases, they may be required to appoint a surrogate parent. And that's when we can't identify a parent, we can't locate them. They're a ward of the state under the laws of our state, or they're an unaccompanied homeless youth under the age of 18. So in those cases, the LEA needs to appoint a surrogate parent. But this next slide kind of puts in some conditions. And so the second bullet says LEAs must ensure that a person selected as a surrogate parent is not an employee of the USBE, the LEA, or any other agency that is involved in the education or care of the student, has no personal or professional interest that conflicts with the interest of the student, and has knowledge and skills that ensure adequate representation. I share this because this is the section that prevents caseworkers or group home employees or any of those things from serving as the surrogate parent. All that said, I am aware of situations where the judge has appointed someone like that to be the parent. And as we saw in earlier slides, that's okay. So if the judge has said that that person is the parent, that fine. But what I'm seeing in the field, and what you've maybe seen as well, is that it's unclear who the parent is. The LEA or the school hasn't figured it out, and the caseworker kind of steps up and thinks that they're the parent. They may not know this law. And so we're going to talk about IEP team participation, but for purposes of who the parent is under IDEA, you can't be an employee of an agency that's involved in the education or care of the student. And because of the second bullet, there are often personal or professional interests that might be conflicts. So I know that's a little bit of a tricky issue, but I hoped that this resource could be helpful. And again, call me if you have questions with interpretations.
Naté, we do have a question. Do you want to address
Okay.
it? Wait, okay.
Yeah.
Okay, so it says, does a child need to reside in a home for a minimum amount of days for the foster parent to serve as the educational parent?
That is a good question, and I don't have an answer to that. I did talk with Laurianne Thorpe about that like a year ago or 2 years ago, because she was like, that's weird that it says ongoing long-term parental relationship, because a lot of our foster kiddos have not been anywhere long-term. So I am not aware of anything that specifically outlines that. There may be some case law where people argue about it. I guess I'd just say that relatively speaking, that's sometimes what judges look at, like what's reasonable. And if you feel like the amount of time the student has been with them is similar to amounts of time that many students are when someone would take on that role, then it's probably reasonable. I'd be concerned if it was a very short-term relationship that didn't seem like it was going to be ongoing. In that case, we may want to identify someone else or appoint a surrogate, but maybe keep that person in mind if they stay in this, if the student stays in that placement and at some point we feel like it's stable and we can appoint that person as the parent. Any other questions, Amanda?
She just added to the comment that she was told 30 days, possibly 14 days, but that might be a district specific.
It might be. I mean, 14 seems kind of very short to me, but I am not in the business of interpreting policies for districts. I can't give legal advice. So I think for me, the key is what is the spirit of this law? And I think this idea is you do want somebody who's going to know the student and be involved as much as you can. That said, if it's a choice between a surrogate versus someone the student has been with for a short amount of time, I think it's up to the school and, you know, working with whoever the parent is to determine that might be the best case scenario for that student, and it would probably be appropriate. One reason why it's important to determine who the parent is because that's the person who can give consent for evaluation or for services. And so it's key that we don't have folks consenting to things that they don't have the right to consent to for our students. This is a safeguards book that is given to parents, and I just wanted you to be aware of it. You've maybe seen it floating around at IEP meetings, but it kind of outlines the rights that parents have in this process. And I just wanted that to be available to you as a resource. I also wanted you to know that we have a variety of dispute resolution services that the law gives to parents and schools to work through difficult things. And I'm not guessing that you would access all of them, but in your role, I wanted you to be aware that if you're part of an IEP team where there's a lot of conflict or we're having troubles making decisions and moving forward, we offer IEP facilitators. And those are neutral folks who can come to the meeting. Right now it's virtual, but they're trained in helping people communicate, helping identify goals, helping the group move forward. It's a free service. It's just voluntary, meaning both the school and the family need to agree to have that person participate. The other thing I wanted to make you aware of is the state complaint process, because that's something that can be utilized by anyone. So if you have a concern that a district is not following special ed law and you feel like you've tried other options and have a lot of concerns, you could file a complaint with our office and we would investigate that. Now, of course, because you are employees of these districts, what I'd encourage you to do first is to utilize those informal options. And please reach out to me if you're just needing somebody to kind of problem solve with. I hope that in most situations you're able to resolve things internally, but I just want to make you aware that there are these different options. We also have parent advocates through the Utah Parent Center. So if you're happening to connect with parents of kids with disabilities who seem like they want help and need information, that's a free service available to parents throughout Utah, as they can call. And some of those advocates can attend IEP meetings. Some of the districts you work in actually fund a full-time advocate just to work with parents in your district. So it's nice to use them as partners in the work.
Naté, we had a question. You might address this later, but I wanted to ask it just in case. When there is a referral for special education testing, can that come from the caseworker, or does that need to come from the proctor or foster parent?
Great question. So what I would say is the law allows parents to make referrals. And when I say referral, that means telling the school you think your student may need an evaluation, may need special ed services. So the law allows parents to do that, and your school district should have a policy for how they handle those requests. Typically, they are routed to the special ed department, and those folks coordinate with the principal or the administrators to follow up on that request. In terms of other folks, the law places the primary duty of determining if a kiddo would need an evaluation or special ed on the school. And the school often has internal policies as to how that is done. Some of you have probably heard of like student support teams or the PLC or the MTSS or the RTI process. All of these are kind of different teaming processes. And particularly when it comes to academics, most schools, if they identify a student that's struggling, will first engage in some intervention to determine if the student responds to that before they refer them for testing and move that process forward. So if it's coming from school staff need to work together to follow that internal process, and different districts handle it differently. So I can't completely say like one size fits all. I think the key thing is that the law triggers that duty to test and evaluate a student if we suspect that there's a disability that would require special ed services. And so that's the trigger. And I want schools to be aware of that, because sometimes they stick really hard to this process of, oh, we think this kid might need special ed, but now they have to do 6 weeks of intervention before we even start testing. That's not consistent with the law or Department of Ed guidance. Department of Ed says as soon as you suspect a disability, you get consent and you move forward if you think the student might need special ed services. You can do those interventions at the same time. So you can be testing and providing intervention and use that data. So there are some kids that we aren't quite sure, and doing interventions might be appropriate in that case. But if we suspect a disability all along, we need to move forward with testing. So I hope that I answered that question. I mean, I included some slides in here. Child find is just the part of the law that says we need to locate and identify and evaluate kids that might need special ed. And again, I think you're key in that. A lot of kids by the time they're older have been identified. But the fact that you're closely tracking these students and paying attention to things that they're struggling with, that's valuable information for a school team. Because if you suspect that the challenges may be related to a disability, that's when we would want to evaluate. So I included some triggers, but it's just interesting. That's a lot of the information that you're actually paying attention to. I wanted to touch on something really quickly. The law talks about what special education is, and it says it's specially designed instruction. And what that means is we change how we provide instruction to the student. We adapt it. And that either means we're adapting the content, what they're learning, we're adapting the methodology, how we're teaching it, or that delivery. And just through doing this work, there are some folks who think special education is a place, like the student goes to that room and gets their services. It's not a place, it's a service. And if you have kiddos that are struggling, even with IEPs, often a key that's missing is we're not changing how we're providing instruction. We may be giving the kiddo more time to do their homework, more time to do assignments, letting them test in a different area, sitting at the front of the classroom. Those are all accommodations, and that's a part of a plan. But if we're not changing how we provide instruction, they probably won't make that much progress, because we have data showing their brain works differently and their body works differently, and they need that adaptation to make progress. So I think it's a key thing to kind of pay attention. Are they getting those education services on their IEP? And what are those looking like? Because that may be why they're not making progress if they aren't. I tried to have a little graphic in here so you guys could kind of have an idea. A couple of you asked about timeframes. So we talked a little bit about when you suspect a student might have a disability or a parent brings that concern to you, that would be a time to decide whether you're going to move forward and get consent from the parent to test. That evaluation period starts once consent has been given, and the school has 45 school days to complete the evaluation. It's important to remember that they're school days. So if we get that consent signed in the spring, we're gonna have a pause in the summer. We're gonna come back to the daily count in the fall. That said, I have some districts who have refused to start testing in the spring sometimes because of this, and there's no provision for that in the law. So we need to get consent signed and move things forward, knowing that non-school days we won't be doing these activities. That said, the distinction is if it's a student in DCFS custody and the school determines to evaluate, or the parent requests that, whoever the parent is, then that is a tighter timeline. It's 30 calendar days. And so that will be for some of your students. And because kiddos move around a lot, and we want to make sure that we can get that done as much as we can. So I just try to kind of give us a flow chart of how things go, and you play a role in that. This is what the law says the IEP team is composed of. So we see some required members. We've got parent, we've got at least one regular ed teacher, one special ed teacher. We have someone we call the LEA rep, who's usually the principal, and they're a person who has that ability to designate resources. They're in charge of things. They're knowledgeable about everything. You fall often within that second bullet up from the bottom. At the discretion of parents or LEAs, other individuals who have knowledge or special expertise regarding the student. That's you. You have that special expertise. So there may be times where they might invite you, or they just might ask you to share information prior to the meeting so that you can contribute to IEP development. So I'm not anticipating you'd always be apart, but I can see that there may be times where the LEA may want you to come join. And I know that some may be newer than others and some may be less experienced. So this is a link to a great resource that kind of walks you through the different components of the IEP. And so I wanted you to have, clearly this is kind of a national example, so it doesn't look like some of the ones you might see. We don't have a one program throughout the state, so different LEAs use different computer programs in different forms. But what I wanted to talk about is this participation section, because we got some questions about that. At the end of an IEP, there is typically a sign-in sheet or a participation section. And this is different in different states. So if you've participated in any special ed processes in another state, it may be different than what you're used to. But in Utah, a parent signature on an IEP just means that they were there. Your signature on an IEP just means that you were there. A caseworker's signature. In Utah, signatures don't mean agreement or disagreement. It is not a contract that won't go into place unless everybody signs. I do encounter some parents who refuse to sign because they're not pleased with the contents. That's okay. I tell LEAs, don't die on that hill. Like, just the point of the signature is to indicate that you were present. Like I talked about earlier, there are certain parts of the process where consent is asked for, and that's fine. If the parent doesn't sign in those cases, then yeah, things will happen. But in terms of an IEP, anybody who's present should sign. But I think some of the question kind of gets mixed up in who is the parent. And that's why I wanted to try to talk about that first, so we could kind of be clear about who would give consent or who's that required person to be there versus everybody else. But generally, this section just shows that we had a properly composed team. I've got some stuff in here about least restrictive environment, just some picture representations of the various ways in which kids can receive services and supports in the school environment. And as you can see, the law places a lot of emphasis on kids being in regular education as much as possible. And so in your role, if you're seeing kids not making progress or kind of being removed from that environment unnecessarily, I really want teams to focus on what supports and services they provided before we move the kid out of that environment, and what could we do to help move them back in. I also included some questions. If you have access to a kiddo's IEP, these are some really good thought questions. When you experience challenges with things, it often comes down to these questions. Alignment, what I mean is the beginning of the IEP talks about a student's needs. Are the goals connected to that? Are the services connected to that? And you know the student's individual needs better than some people do. And so it's that idea of knowing what you know about them. When you look at this IEP, do you see connection to their specific needs? And do you see services and goals that really connect to what they would need to be successful? When I talk about implementation with fidelity, what I mean is it being followed? If the student's supposed to receive 30 minutes of reading services a day, is that actually happening? If they're supposed to receive accommodations in terms of testing in a different environment or extended time, is that happening? And that second to last bullet talks about, is everybody aware? Sometimes they're not, and that's where we see breakdowns. A component of the IEP process is it's reviewed annually, but there are progress checks along the way. And those are supposed to report how the student's doing on their IEP. And so I think this really aligns with the work that you do. You're doing progress checks all the time. And so I wanted you to be aware of, so you could advocate for your kids that although the IDA says we need to review once a year, they also say there are these other circumstances that may require the team to meet again and to make some changes. And that includes when a kiddo's not making progress. That includes when new testing comes about, or information is provided by the parents, or we have other information that the student has different needs. A lot of our students involved with youth in custody and youth in care are getting testing or being evaluated, or things are happening kind of outside of school. And everything doesn't always need to be shared, but I think it's just important to keep in mind as a team supporting the student. Is there any new information coming to light that could help us better support the student or tweak their plan? And so we just always want to be aware of that. I'm just checking my time. I've got a section on best practices in IEP development, and I just want to put in a plug for this project that Virginia's been doing for a long time. They really believe in the concept of self-determination, which I think is a skill for our youth in custody as well. And self-determination goes beyond self-advocacy. It goes to choice making. It goes to understanding your disability, what your needs are, and learning how to advocate for supports. And they have a lot of great resources for years, for probably the past 15 years. They've been involving kids from kindergarten all the way through post-high in their IEPs. They've got videos, they've got one-page sheets that kind of are quick and dirty worksheets to help kids prepare. And I really love their resources and did work with them when I was on the East Coast. And so I'd encourage you to check those out. I'm just going to skip through these, but just some good tip sheets on how to collaborate if you're ever participating in a meeting. And then my last two things I wanted to touch on are two things that are key in the law that I think often come up with this population of kiddos. First, there's an element of the IDA that says when kids are 14 and older, they need to have a transition plan. And I think the term transition can get tricky with this population because we have a lot of transitions going on. But in this case, it's connected to post-secondary planning. So what is a student going to do for education, independent living, and employment once they leave us? And as such, they're supposed to have goals. They're supposed to have activities that coordinate with that. And I just put in a plug that these kids should be working with their guidance counselor or their school counselors, just like any kids should. There is a tendency in the field that some kids with disabilities don't really have access to those same supports because in the school environment, guidance or the school counselors think that special ed will take care of it. So for me, that's an equity issue. I've included a resource that the Parent Center has about transition that I'd recommend. We also have a ton of resources on our website and several specialists who just do this job full time. So especially if you're working with kiddos in high school age with disabilities, know that there are some great resources available. The other thing I wanted to just briefly touch on is behavior and discipline, because that can come up with this population and just with kids with disabilities in general. A lot of my work surrounds these calls. So in Utah, we have a manual called the LRBI. It stands for Least Restrictive Behavior Interventions, and it focuses a lot on proactive things and evidence-based practices that help our kids be successful even when they have behavior challenges. The team is required to review this manual and to review supports if a student has behaviors that are impeding his learning or the learning of others. So I want you to be aware that the team needs to be addressing through a BIP and an FBA. I also wanted you to be aware that there are discipline protections for kids. That doesn't mean that kids with IEPs can't be suspended, but what it means is that after a certain amount of removals, different procedures kick into place. And I could spend a whole day talking about those, but this is a really good flow chart to help you just get the basic idea, and you can reach out if you ever have more questions. So I wanted to remind you, we have a great website, but it's kind of hard to find sometimes if you just go to the homepage. So I wanted to link you directly to it. The Parent Center, like I mentioned, is an awesome resource. These are some other websites or books that I think parents have found to be particularly helpful in their practice. And so I'd encourage you to utilize them if you have questions. And then here's my contact information. So I think we have a few minutes for questions if we've got some questions from the group.
We've got one right in the chat here for us, ready to go. And we've got a few minutes, absolutely. So the first question is, they have a student in a co-taught language arts class. He has an IEP and there's a special ed teacher in the class, but they're seeing him not be successful. Is there a reason why co-teaching in core classes? Has this come down from the state or is that a district thing?
Great question. So co-teaching is a best practice in the field. Across the United States and in Utah, it's a practice we promote because the research shows that kids are most successful academically when they're in the gen ed environment as much as possible. The more kids are pulled out of the gen ed classroom, even if they're getting those supports and services in another place, they do not perform as well as students in the gen ed setting. And so this practice has developed over the years with research base, but true co-teaching is that gen ed teacher and that special ed teacher working together to plan instruction that can adapt to the needs of all kids. And so there is a push because the data show, and we've done a co-teaching, we've had cohorts across Utah, particularly in the area of math, and we've seen kids go up to 1 grade or 2 grades higher simply by being in those core settings with more support. That said, just like we talked about at the beginning, an IEP needs to be individualized and we do need to be seeing progress. So if we're not seeing progress with a kiddo in a co-taught classroom, it's still an appropriate time to kind of look into that. And is it because of the setting that they're in and they need to be in a setting with more supports, or can we push more supports into that gen ed setting? So it is a best practice that we're promoting because the data really supports it.
Naté, can you hear me okay?
Uh-huh.
Okay. I have a question. I've got one student who is in 3rd grade, and he is probably in some areas working at a kindergarten or 1st grade level. Mm-hmm. And because he is been in custody, he's back placed with parent, but parent doesn't make him go to school. So he's missing 40% of school. And so because of that, they're not testing him and finding out what we can do. But when you said that we should be able to at least get some of those things in place while we're testing or something, is that something that's possible in all of the school districts, or is that something specific to school districts?
Great question. I mean, I think the challenge comes to eligibility in that thing I talked about, suspicion of a disability. And so especially when we have kiddos like in this situation you're describing, the school may be right now saying, yes, student is really behind, but we don't have a suspicion that it's a disability at play. It could be what the law calls lack of appropriate instruction. And that is a reason that would make a student ineligible for SPED services. When we test a kiddo, if we can tell that the key reason they're behind is because they haven't received instruction for whatever reason, it's often attendance or truancy stuff, then we may not move forward because we say it's not a disability from our perspective, it's this lack of instruction. It's a tricky question because what my guidance to schools is if you have evidence of a disability, you still need to move forward with testing. In some cases, they may not have that, and so they're not doing that. That said, throughout the state, we have multi-tiered systems of support. We have response to intervention. And a key thing I want audiences to know when I train is special ed isn't the only way for kids to get support at school. It used to be years ago. And that's where we saw some kids incorrectly identified because schools thought, well, this is really the only way to get support. But there are state laws about things that a school district needs to do when kids are not attending school. And there are systems in place for kids to get tiered supports and interventions. And so it's a case-by-case basis, but if there is any evidence that this student has a disability, they should still move forward and not just kind of make the decision without evaluating, because you want to show you did your duty. You shouldn't only evaluate when you're 100% sure. That's not the point of evaluation. The point of evaluation is to dig in and see. And not every kid will be found eligible, but there are other supports in the school that should be being provided to help the student access and make progress.
Okay, the thing that's concerning about that is our school district chose not to worry about attendance this year because of COVID. So they are not taking that into account on being able to like send the information to the administrator so the administrator can pass it on to the district and follow through on these problems with attendance, where this is definitely a parent problem. And so there really isn't any way to, this young child did have a IEP for speech, and he is now just, they're dropping him out of that now because he is caught up with that, with his speech finally by 3rd grade. And so he will no longer have an IEP even for speech. So I'm just not sure where to go with this. The teacher feels like he needs to be tested, feels like he's has some problems, but I'm just not sure what can be done.
Well, I mean, welcome to call me. I talk to schools and families about issues. I can't give specific legal advice, but I can kind of explore the options. The school has a duty to move forward if they feel that that's in place, but that's why some people use dispute resolution when they have concerns that's not happening. I do have widespread concern just about kind of excusing any issues that occur this year due to COVID, in part because, as you all know, that won't make them go away next year. So whatever we can do to support kids now will benefit them and us in helping them move forward. So I just continue to advocate. And if they're not willing to test or move forward in that area, then I would just continue to say, well, what supports do we have in place for any kiddo who's performing below grade level? Schools are still receiving ratings on their standardized testing year by year. And when they have kids who are below proficiency and they have a big percentage of them, they have to do additional work through turnaround or other things. So I still expect administrators to be responsive to any student they hear about who's several grades below level. So if it feels like the special ed route is a dead end in your role particularly, I would just continue to say, well, what do we have for kids who are slow learners in these grades or who need help with reading or math? And most districts have built out multi-tiered systems of support, and I would expect them to work on that. I see Annie has a question about progress. And yeah, progress is somewhat dependent on the student. But what I would say is some of it is a judgment of how they're performing in relation to their peers. And then some of it is a judgment about how are they performing based on what we know about the student. There are certainly some kids with more significant disabilities that will make a slower rate of progress. And we expect that because of what we know from testing and from data about that student. And so even when they make incremental progress, we can say that student made progress versus others. The Supreme Court case that I talked about earlier said for many kids who are in the gen ed setting, if they are passing and moving on from grade to grade, then that is considered progress under the IDEA, but they said for kids who are not in the gen ed setting, are kids with more significant disabilities, that's where they said they need to have challenging objectives and goals that are appropriately ambitious, but we can't measure their progress in the same way. That said, you make a point that I feel passionately about, where you say, I have a student with behavior issues who's taken to a behavior intervention program half the day. I'm not sure what that program looks like, and we could talk more offline, but what I would say is we have a specific concern about kids with disabilities nationally being secluded, being restrained, being removed from educational settings because of behavior. And that's kind of why I tried to point out that manual at the end, because that is a key thing. We have evidence-based behavior supports that can help students, but sometimes the school's response is to remove, to suspend, to expel or send home. If we're seeing a pattern of that, particularly with kids with disabilities, that should be an indication to us that something's not working and we need to re-examine supports and services so that we can help them be successful and make progress educationally. And one last thing, what I'd say is the law says progress in the IEP is connected to academic, behavioral, and functional. So there are times where schools have said, we're not giving an IEP because that kid has a high IQ or that kid has good grades. The IDEA goes broader than that. And I think particularly our group of kids, we have some kids who are super sharp cognitively, but who have functional and behavioral challenges, and special ed should address those things as well if it's connected to a disability. So any other questions before I sign off? Okay, well, you guys were a great group. Please reach out if you have specific questions. You can call me, you can shoot me an email, and I'm happy to work with you. So thanks.
Awesome. Thank you, Naté. That was a great reminder and review for some of us that may have forgotten a few of those tricks or some new information for the new kids on the block. I appreciate your time this morning. So next we will be hearing from April Graham and Jackie Chamberlain. And these ladies are from JJS. Jackie, did you want to share your screen or April, or do you want me to share the copy of the PowerPoint? What works best for you guys? Jackie, you're still muted. I can see you.
Sorry, I'm happy to share it.
Oh, perfect. You should be able to just from the menu on the bottom of your screen. One thing I will point out, if you have multiple screens, you can either share the screen or the actual PowerPoint. Just heads up on that one. I always end up sharing my email if I'm not paying attention. So I just wanted you to know the multiple screen trick.
Does that work? Can you see?
Yes.
Okay. Hi, everybody. So I'm Jackie Chamberlain. I'm the Public Information Officer for Juvenile Justice Services, and I previously was the Education Liaison for the Department of Human Services. So I'll just jump right in. We're going to give you an overview of Juvenile Justice Services. And
you want me to introduce myself too?
Oh, yes. Yes. Go ahead, April, please.
Go ahead. I'll just stop. My name is April Graham. I'm the program director over our community programs. So I oversee our case managers, our parole officers, the DSI programs throughout the state, day skill intervention, and Gemstone, and our Alta unit down in Springville.
Okay. So we'll probably end sooner unless you guys have a lot of questions, but I'll just dive right in. So the mission of Juvenile Justice Services is to change young lives, support families, and keep communities safe. And we always want to qualify that we do that in collaboration with the schools, because we don't operate in a vacuum or in a silo. And so we definitely need our school partners to make successful outcomes. I'm not sure if this PowerPoint is working. Do you see the division goals?
Yes.
Okay, great. Our 3 goals are to improve short-term and long-term outcomes for youth, support families in the rehabilitation process, and improve safety, security, and well-being of JJS youths and employees. I don't know if you guys have heard of the youth services model, but when we passed reform, juvenile justice reform in 2017, we really focused on pivoting our system so that low-level youth who might just have misdemeanors and low-level offenses were no longer locked in detention. And so we, in the last 2 years, we've really formalized our youth services. It used to be called JRC. There were a number of different names for this umbrella, and now we've formalized it under the youth services model. That is, I'm sure those who live in Salt Lake County Youth Services is one of them. We have them throughout the state. We contract with some youth services, but we also work in collaboration with in our own facilities. They're multi-use facilities. And this umbrella really, we connect to community resources, we do skill building classes, youth and family plan management, community projects, and family activities. We procure services with private providers, and that's what I'm saying. So what we do is when a kid comes in our door, they will work with the local mental health authority, or we'll work with private providers if a youth needs to have extended services outside of our system, outside of the formal juvenile justice system. And then we provide counseling, support, and residential services as well. We believe in a system that works for families, strengthens trauma-informed community resources, and finds the least restrictive means of connecting youth to services that will help them thrive. So when I say we formalized our system, what that means is when a youth comes in our door, it's very, it used to be a youth would come in, we would maybe screen them, move them over here, and then we didn't have any kind of formalized approach. Now what we do, anybody can refer a youth. Schools, and you can see families, a youth can just walk in our door, and we have an online referral process that makes it really, really easy. So you can just go online, a family can go online, and they can just say, you know, I need, my child is having problems, or a school counselor can go on, or a mentor, or a youth in custody. Any of you guys can refer a youth who's struggling, who may be at risk, but isn't quite, you know, court involved yet. And you go to jjs.utah.gov to do the referral. Then we do a formalized screening. We ask a series of questions, evidence-based screening tools. We screen for mental health. We do something called a MACI. We also do a suicide screener. And then what we do is if they flag high in one of these areas, like suicidal ideation, then we will do a full assessment. Sometimes we'll do a protective risk. What is it, April? I'm going to jump to you.
Protected risk assessment.
So if they flag in some of the criminogenic risks, so they may be, you know, acting out, then we'll do a protective risk assessment.
So those are mainly for kids who are court involved or have charges in the juvenile court system.
Mm-hmm. And then we'll create a plan, a youth and family plan, and we do this in collaboration with the family. This is a big change from the way we used to do things. So now we always bring the family to the table, because we realize that we don't, again, operate in a silo, and the best way to prevent them from coming in formally to the justice system is to work in collaboration with the family to find out, you know, a family might be in crisis and they might not understand why their child is misbehaving. And so what we'll do is we'll work with the family so that we can, you know, find out what's happening at home, and we can create kind of a plan with them in collaboration with those other partners I talked about earlier. Then we do follow-up, and we continue to follow them up, usually for 60 days. So this is kind of just an infographic to show that any of these people, a parent, the referral can come from the Department of Human Services, like DCFS, or other partners. The youth can walk in through the door. Law enforcement can refer a youth who might be, say, truant, or they might be smoking on school property. A community member may be able to refer them a school or the juvenile court. And then this is kind of that formal system I was talking about. They're screened, And if they flag for something like, severe suicidal ideation, we would refer them immediately to the local mental health authority or to the local hospital. If we find out that maybe they flagged for something else, we will do the assessment. Whoops, apologize. And then if they're moderate or high or court involved, that's when we'll do that protective risk assessment that we were talking about, that April spoke about. And then we do that family plan coordination. Okay, April.
All right, so this kind of gives you a little outline. We have kind of a vast continuum of services that we provide. So we serve both front-end kids and back-end kids. So when I say a back-end kid, we're speaking at a kid might be incarcerated. So just to kind of walk you through this, our front-end services, our early intervention, is our youth service model that Jackie just talked about. Kids could come into detention and not be involved in youth services or custody. They could be just a one-time situation in court and get a non-judicial kind of assignment through the juvenile court. So there's a lot of different scenes in the juvenile justice system in all. Day scale intervention is typically, it's a program that we provide that also helps to hopefully keep kids out of custody that are struggling in school or other delinquent pieces. I know we also have helped with some of the school districts with their safe school violation kids that are struggling in their classrooms that are set up with the school district. So there are several different kids that we help in this situation. They come to school during the day, and then we do programming in the afternoon with them. A lot of skill building. We do some DBT skills and other things to help them and support their family. When a kid either meets our criteria, if they meet our criteria, they could come into custody. This has to be court ordered by a judge. And through that, we have a lot of different services that we can provide. We can provide services in home. We could provide services in a day program. They could be in a proctor home, which looks like a family setting where a kid can go to a regular community school. We also have group home settings and other things. So we're going to get into a little bit more specifics with that. Our secure care setting is kind of similar. I mean, I say this, but it's not really similar, but it's kind of like youth prison. They're sentenced there, the court jurisdiction is terminated, and then they're turned over to the youth parole authority. And then after any of these services, we have transition services that we help these kids either out on their own or back to their home or kinship. So this kind of gives you this kind of bigger picture as far as how many different places that they can kind of connect. You can have a kid who comes from a parent and gets referred to youth services, or they could have some delinquency issues and also get referred to youth services in more of that front end aspect in more minor situations. So there are a lot of different YIC placements that we utilize. We have regular classrooms that we utilize in community schools. There's, we talked about our DSI program a little bit. There's also alternative schools, which you guys are all familiar with, and, special school settings within their school and home and hospital that we utilize. So here's some changes. I know you guys probably have heard of juvenile reform. 2 years ago, well, was it 2 years ago now, Jackie, or is it 3?
3 years ago, yeah.
It seems like a lifetime, but it's been progressive through the whole 3 years, and it seems like a little bit has changed every year. But some of the biggest things that were changed is it made it more difficult for kids to come into custody. So some of the things, or into our detention facilities, some things that we would see is sometimes kids would come to detention for truancy because they were court-ordered because of maybe a contempt charge or something like that. So they end up in detention primarily for truancy, but if they didn't follow through with their court-ordered plans, then they could find themselves there. And then also into custody. We've had several kids previously that's kind of their first dip into the system, as they had contempt charges on a truancy issue, which pushed them deeper into the juvenile justice system. So some of the things that were changed was this detention guideline. The biggest key changes is that previously a youth had to have 3 misdemeanors or more in a single criminal episode. And when they talk about a criminal episode, an episode is really just everything that's encompassed in an act. So for instance, we would see kids who would come in for maybe theft and now I have to think about this right off the top of my head. Assault or fleeing from police officers, right? All of those were misdemeanor charges. They might have stole something, and then when they were trying to pick them up, they fled and had something else that might have happened. The other thing that we saw was that sometimes when an officer made contact with a kid, they would inflate the charges and kind of almost in a sense double charge them. So you can have an assault that happens, and you could also be charged with criminal mischief, which are pretty much the same thing in that act. So they try to streamline this a little bit better. And then the other thing is these younger kids. We typically having these really young 10, 11-year-olds. And I'll tell you, it kind of melts your heart when you see these little 10-year-olds come into a detention facility, and the clothes that we're trying to put them in is like 3 sizes too big. And then kind of figuring out that there's probably a lot of other things going on in this situation than just the intent of being delinquent. So some of these things changed to where a 10 or 11-year-old could only be admitted on certain felony offenses. So these are more aggravated offenses and against person. Any Class A misdemeanor against a person, a child can be held for, which is actually, if you take a look in the removals, they would have had to have had 3. So really understanding that these kids that are a little bit more aggressive towards other folks probably needed to be picked up. Any Class A or B or weapons related charges, any Class A misdemeanors that are sexual offenses. So really kind of looking at those against person type offenses. And then any new Class A misdemeanor traffic related offenses, which really had more to do with DUI and, again, those against person kind of offenses. Did we have any questions? I just want to ask, this is a lot of information to kind of take in.
Nothing in the chat so far, but if folks have got questions, they're welcome to pop it in, and I'll interrupt you guys as you're moving along. Perfect. All right, so we'll kind of go through these programs a little bit more specifically so you guys can understand a little bit of the difference. Is the system, I think the juvenile justice system is a little complex, and it's interesting even when you meet people and talk about some of the work that we're doing. Being able to differentiate between a probation officer and a parole officer is, I mean, in our world, we kind of feel like it's very simplistic, but I think in the community and with people that don't interact with it very often, it seems a little bit more complex.
So one of our other earlier intervention programs is home detention. So when a youth comes into detention for one of those previous offenses that April mentioned, if they'll do a detention risk assessment tool occasionally, and they'll, work with the courts and decide that maybe a locked detention setting isn't quite the right place for them. And so the judge will make the determination to send them home. And our staff, JJS staff, will be monitoring them at home. We do phone calls. Sometimes we go to their homes. It's a community alternative to locked detention. It provides community supervision, phone contact, face-to-face contact. We work with a parent or guardian. And then the length of stay in the program is individualized. And we do this in collaboration with it's determined with by the Utah Juvenile Court.
Yeah, and a lot of it was just really trying to prevent having low-risk kids mixed in our detention facilities with other high-risk youth, because that's one thing throughout the research, throughout the 30 years that there has been some good research on what works with folks that have delinquency issues, is just knowing, and you guys probably know this as well, when you work with adolescents, right? Who are their main folks that they are engaging with? And they're typically their friends and their peers, right? So when these things are generally accepted, contagion happens pretty easy. So another service that we provide through Juvenile Justice Services is in-home observation and assessment. This is kind of a change with reform. This used to be a residential program, but then kind of really looking at the types of kids that were coming through and where they were going at the end of this stay with what we call O&A. We found that there were a lot of kids that were lower risk youth that were being removed from home for 45 days and then returned. So to make this more least restrictive, this operation was moved to an in-home process. So we assign a case manager. They go into the home with the youth. They work with the probation officer. They might have some other services happening like in-home detention, or they might be involved in one of the day programs and so forth, just to help with supervision. But really kind of getting a look at what that youth needs on their family dynamics, the behaviors that are being seen, their social and education. Those things are all assessed within a 45-day period, and then their return to court, along with their mental health assessment, and if needed, a psychological. Day skill intervention it's typically a 90-day program, but it's also, we try to really be individualized to make sure that the kids are getting services and the family is receiving support in their community. They come to school during the day. It's a smaller classroom. Kids, I'm always amazed at how well they flourish. So kids that have typically never really seen success in school get into a program like this. And when you only have 6 or 7 kids in the classroom, they get a lot of one-on-one attention. What we also find is a lot of them are on IEPs, or they have some significant behavioral problems in school settings, and they typically kind of soak up this smaller setting. We also work with them after school to build skills to reduce their risk for recidivism with their delinquency, build social skills, and really try to work with their parents to translate this stuff back to home. So the state contracts with several private providers that provide residential treatment. Those kids are court-ordered into custody. They're removed from home and placed in a program. Our presumptive length of stay for kids in residential is 3 to 6 months, unless there's some other issues that occur, like if a kid gets a new charge, or if they go AWOL, or they have some significant issues that would present them from kind of going backwards because it's not clinically indicated, then they could stay in it longer, but we have to make a finding with the courts. We have to go back and justify why, if they're removed from this level of care, it would be counterindicated for what they need clinically. The Gemstone program is a female residential program that we run through the state. There are a few other private provider ones as well. We really do try to make sure that we work with these kids to provide support to them and do outreach with their families. They also receive education services on site. They're typically involved in therapy and group therapy. We're doing DBT with these kids, and also other criminogenic type programming to reduce recidivism. And then we're just starting a girls specific program that we've been working, trying to build some of the relationship. Girls and boys look a lot different when they come into custody, and the reasons. Girls, we find, have a lot more trauma. And it's quite interesting how typically, you know, when girls come into care, it's usually because of safety for themselves. But they're just dealing with a lot of stuff usually. So there's a question here if there's an equivalent to gemstone for males, and there are. Usually we have several private provider agencies that do residential services. I think the only reason that we've kind of stayed with gemstone is it's hard to get people to work with girls. I don't know how else to explain it.
And it's also, yeah, it's hard for private. Oh, sorry. Hard.
We can hear you.
Okay, sorry. It says it's muted. So it's really hard for private providers to, it's a small population and they're really, really complex. Like April said, a lot of them have severe trauma and behavioral and mental health challenges. And so private providers, it's not, you know, the cost benefit analysis for them is that it's easier to work with boys. So we keep that going.
Secure care, when kids are, I mean, these are usually or typically are more aggressive kids in the community or dangerous. So for community protection, they get ordered into secure care. There's a lot of treatment going on in secure care after reform has happened, which has been fantastic. These kids, all of our kids across the board, though, in our residential and secure care, if they're high-risk kids, they're getting 200 plus hours of evidence-based dosage. So we're talking, you know, DBT, cognitive behavioral therapy, and other kind of criminogenic skill development to help build skills for these kids. The presumptive length of stay for secure care is also 3 to 6 months, unless there is an aggravated offense. So there's a list of kind of serious youth offender type offenses, and these are things like aggravated rape or anything that could cause the loss of life. Kidnapping, armed robbery, you know, those kind of things. Those kids sit outside of that presumptive length of stay, and they could also stay in secure care up to age, well, now, since with the last passage of bills last year was age 25. So we've also been working with several higher education and vocational institutions across the state to ensure that there are some higher education abilities for these kids to receive while they're in secure care, especially these ones that will be staying post high school. So we're working with Davis Behavioral Tech. There's also, I think there's also a bill running this year for higher education. So there's a lot of work still going on trying to get all the pieces together. I think we just barely had one kid who was ordered in the last few months who has one of these orders to remain with us until age 25.
And if anybody's wondering why, it's so that they don't go to the prison, because we've been working with the Department of Corrections, and when they go to prison at that younger age, say 22, 23, they're still very immature, and it can be very dangerous for them. They still, they can be assaulted at a higher risk. They have worse outcomes, and that's the main reason why we changed that law.
Well, and brain development.
And brain development.
You guys all know, right? Most of our young adults aren't fully developed, their brain isn't fully developed till age 25. So we're trying to follow that science. Residential support and transition to adult living. So we have this program that we provide, and then there also is another one in Salt Lake called Live for Life Aspen. These are our kids that typically have cycled through the system and need a little bit more additional support. There is statute out there about what kind of programs that we can step a kid down to after residential or secure care. So they can either go to a TAL program, they can go home, they can go to kinship, but they can't step down to like a proctor home or a foster home or those types of things. So, but if any of you guys are familiar, that TAL homes, traditional TAL homes are typically like a basement apartment of a provider's home. So it's kind of like they have an adult living upstairs, but they don't live in the apartment with them. So this is kind of why we saw this need to have something with more support. These are smaller homes. So a typical group home will have up to 16 kids in it. This residential support program only houses 8 at a time. And then usually that we leave one open. So we usually try not to do more than 7. We leave one open for crisis placements. But they really do work on trying to help finish graduation. You guys have some outstanding teachers out there that have helped a ton with some of these kids. I mean, you can see in this picture, there's a little graduation going on. Yep, that's your that's your DSI in Alta down in Springville. Yep. It is, I mean, they've really come in. I mean, this one in particular is Nebo School District. They've really come in and try to help a ton to get these kids on track. And we love that support with the school. So this is kind of our map of services. I think we put a hyperlink in here, maybe.
Yeah, we did put a hyperlink. So
yeah,
I
so
don't
you
know
can go to the website, and if you click on one of, I think if you even click on one of the counties, Jackie.
Oh, yep.
Typically,
I'll click on Salt Lake.
yeah, if you clicked on Salt Lake, you could see all the services that are available in that area and the contact for those folks. So even if you went down to maybe Sevier County, that one's a nice small county. You can see what counties that covers and then the contact information for those.
And the reason why some of these, you'll notice like Mill Creek Youth Center, some of our secure care settings are still going to show on this, because if a youth is ordered to secure care, they could go to 4 different places. They can go to Decker Lake, Slate Canyon, Mill Creek Youth Center, or Southwest. So we had to put those still on there. But that's how you do the website. So I recommend you guys going there, jjs.utah.gov. It's over on the contact tab at the top.
So we place this form in there because I think some of the discussions we've had back and forth with the Board of Education is making sure that we are filling out some sort of information and presenting that to the school. So when our case managers register a child for school, they're required to do this youth in custody information. Now, I'm not sure how that gets passed down to the mentors out there in the school situation, but know that that's there, and maybe you guys could check back with your coordinator to see if there's any additional information on that. Because I mean, they're required to really fill out quite a bit of stuff about their previous services they've received through other school districts and things like that. We usually do an intake. Oh, great. It's good to know that you guys are receiving them out in Tooele. I hope they're going out. I think there was a question whether or not you guys are seeing these or not, but I just want you to know that we are doing them. And if you're not receiving them, you probably should just chat with your coordinator. And then we put a hyperlink in here too for case management, contacts. So each area it has an APD there in red. The supervisors are in blue, and then the caseworkers that work underneath those supervisors. We did change things up this last year. We used to have case management by function, and we pulled them all together. So sometimes, like you'll notice, like Rebecca Hodgins there, she has people in Vernal, in Logan, and yeah, in Vernal and Logan. And then same with our Southern, under Rich, we have Brooke, who has folks from St. George to Richfield. So.
And the final slide. Someone is sitting in the shade today because someone planted a tree a long time ago. You guys plant those trees. So thank you.
You guys tend to those trees.
You do
water
tend to the trees.
You trim the trees, you do all of those things, and we appreciate that.
Well, we appreciate you guys making time to present to us today. I do see one of the participants with a hand raised. So if you've got a question, you're welcome to jump in. We definitely have a few extra minutes here to do some question and answers before me and Nick and Julia share a little more information.
Okay, this is Trina with Granite School District, and we are opening our mentoring services into Gemstone and into DSI, and I'm the mentor that's doing that. And it's been really
about you.
Oh, thank you. What I'm calling, my question and my thing is, I have a little bit of road. I'm paving a road in there because they're not used to a couple of things. First off, I have gone to everything. The school piece is not getting the YIC intake for any of the Gemstone girls. The other piece is that I need to have some kind of thing to be able to be a part of the team for those students that are in DSI that are, PO officers. Is there a way? I mean, because I'm working with the team in Gemstone and DSI, and they're like, we can't give you that information. We can't give you that information.
They can't give you what information?
They can't give me a referral. They can't give me a referral information that you guys send for them to be there. What information that comes on the POP report doesn't give me like their home address, their home school, the things about their background and where they're coming from. And I can't be a part of the team and help support there, build a relationship, and do transition piece when they leave the program. And so I'm just open to suggestions, and I'm just finding different things. And they say that the POs can't do the intake like the JJS workers. It'd be great to have something that when they're involved either way, that we get that stuff so that we can continue to give the service.
I'm going to put my email in the chat.
Okay.
And then I want you just to get a hold of me, and we can set up a meeting with Trina and figure this out.
Perfect.
Because this,
I know she's been trying. Yeah.
It shouldn't be an issue. And I don't know why we couldn't. I mean, we could fill out the form based on what we know, but I don't understand why you can't be a part of the team. So.
Well, the reason why I feel like it's so important, sorry, let me take time, is because I don't want those DSI students that have been ordered to go to there, right? And they come into our school and we're like, who are you? Who are you? I want them to come in and say, oh, we've been expecting you. We're so glad you're here. That's my point, that if we can't get those things done, it happens in regular school settings. I'd really like to see that happen in both of these settings.
Yeah, I think we can get that taken care of. And
perfect.
If we can't, I'm sure we can include some of the probation chiefs, and I know that they would help with their probation officers.
Thank you. That'd be very helpful, because I'm enjoying giving that services to these students that are there in both programs. Thank you.
Well, and we need you there, because that's that transition back to their homeschool is the biggest piece, and having someone check in and help support them that has built a relationship with them is going to be more productive.
Yeah. So thank you.
Okay, folks, you've got the good minds here to ask questions. So if you have any other questions for Jackie or April, now is the time. And like April said, you're welcome to reach out after the fact and email or call if you have additional questions, or like Trina, a specific issue that you need help with.
All right.
Well, real quick before we go to our team, I'm kind of all over the place this morning. Sorry about that. With us today, we also have Trina Valdez, and Trina is the education liaison with DHS. And I just wanted to give her a minute to say hi and introduce herself to the group before we move on.
Thank you, Amanda. Hello, everybody. My name is Trina Valdez, and I am the education liaison with Department of Human Services. I have a very unique position in that my position is funded by 5 different agencies, including JJS, DCFS, State Board of Education, System of Care, and the Juvenile Courts. I will be doing a presentation for you in the near future to sort of talk about my role and the collaboration amongst all of the agencies, and my role as the chair of the Utah Coordinating Council for Youth in Custody, which is the oversight council for the funding piece for the programs, including Check and Connect. We also have a Educating Youth in State Care guidebook that will be available by print and through our webpage in the next few weeks. It has a lot of different resources on it. And there's a section for each agency, including JJS, that has some informational portions to it that'll cover some of what Jackie and April covered today, in addition to a piece on probation, special ed, the schools, etc. So I think Amanda just wanted me just to say a quick hello, and I look forward to doing a presentation, I think in probably the next few weeks or next month, to sort of talk about the collaboration piece amongst the agencies and how we can all work together. Thank you.
Thank you, Trina. And yes, I'm going to look at the schedule. I think next month actually fits right into the schedule. We're going once a month now that school's back in. So thank you so much. Lovely to have you with us. Okay, so let me get my screen back to where we need to be. And then I'm going to have Miss Julia talk to us real quick about the umbrella of services.
I think this slide here for all of you, thanks for letting me be part of this. I love these webinars, and I think what the work that you do is so awesome. I worked for DCFS for 13 years, and then I worked with the Office of Quality and Design for a year before coming here. And so this is really where my passion lies and the work that you do lies. I've been able to work with many of you, including Kelly Russell out in Tooele, and some others, and that was a great opportunity. And I just wanted to give you a little bit, I guess it's maybe a sneak peek to the presentation that Trina is going to have for you coming down the road. And it's just a slide that I wanted you to kind of get an idea of what Department of Human Services entails, and those agencies within Human Services that you will potentially come in contact with, including JJS, obviously DCFS, and also recognizing that these are different agencies. So you are probably going to touch in these agencies, and in some more than others. So right now, the majority of you are working with DCFS kids that are in custody. Some of you, like Trina from Granite School District, is just opening the door currently to working with some JJS folks. So that door might open down the road, and it's something that's in conversation, but isn't quite there yet. So in this presentation today, it's important for you to understand JJS, the model that they use and what is available through JJS, because you might come in contact with these kids through other avenues, right? So some kids might be in JJS custody and go into DCFS custody, and now they're on your caseload, things like that. So it's important for you to understand that we are sister agencies, but we are not the same agency as far as DCFS goes and JJS goes. You also might touch agencies like Division of Services for People with Disabilities. So they have support coordinators. You may come in contact with one of those. And so that's important for you to know. And also I have highlighted on this slide, Office of Quality and Design. That's the agency within Department of Human Services that creates the contracts with providers. So those proctor homes, residential facilities, and then they also oversee the monitoring of it to make sure they're doing the job that they're supposed to do. And so these are all various agencies that you may come in contact with. Something that is shared among agencies, and I think this is the next slide, Amanda. after that one, I think, is that a lot of these agencies have child and family team meetings, and I think they even call them the same thing. Correct me if I'm wrong, Jackie or April. I believe they're all called the same thing. And this is a great resource for you to get involved in these child and family team meetings, because all of the key players on those teams are there. And so if you do have kids that are JJS associated, then we encourage you to get involved in those team meetings as well as your DCFS team meetings. And Amanda, I think that's all I have, but what questions do you have about maybe those two things that I talked about today?
So like before, you guys are welcome to unmute or pop any questions you have in the chat.
I'm just lucky I get to work with both.
Yeah.
I get DCFS and JJS, so.
And you get to see the ins and outs of how things are different, but there are still some.
Yeah. In fact, I'll tell you, JJS are less likely to invite me to their team meetings than DCFS. I never hear from a JJS for a team meeting.
Well, now you know they exist, so maybe push a little bit.
Yeah, I knew they existed, but I just usually have that group home, Live for Life Cyprus, and I don't know how they're doing theirs right now. So, and of course, their changeover of program managers has been a lot.
Yeah, well, we do want school folks involved. They're supposed to invite. I think that they rely on the group home to include you because you probably work more with them. So those are probably just questions for whoever you're working with directly. Yeah. And then, but you said you were getting the forms.
Yes, I get all the forms most of the time.
So you should have the case manager's contact information on there too. And it might be good just to shoot them an email just so they know who you are. And
I had one of their one of my boys at the group home. His mother called me the other day.
Oh,
like,
nice.
I don't know who you are, lady. I was nice. Well, she had to leave a message, so I didn't call her back. I just let the group home know, hey, this woman's calling me. So.
Any other questions? Then I think the next.
I didn't have a question, but I did want to jump in and thank April and Jackie. I really appreciate the working relationship that I have with JJS. So I did want you guys to know that. I get to work with DSI occasionally, out to program youth, but mostly secure care. But I appreciate the working relationship with JJS. So I just wanted to put that out there.
I know that Rachel's going to get a hold of you because we talked this morning about trying to make sure we get the mentors connected to the DSI kids more quickly before they go back to their home school.
I think that's a great idea.
Thank you, everybody. It was great speaking with you today. And I have another meeting, so I'll say goodbye now.
Well, thank you, Jackie. And thank you, April. We'll hang on for just another minute. April, you're welcome to stay with us, or if you've got to go like Jackie, we understand. We're just going to cover a little more information. So Nick, if he's there, is going to talk to us for a minute about weekly updates. There he is. Hi, Nick.
All right, slowly pushing buttons. So Amanda, I just sent you a message. I don't know what I'm supposed to say on this slide. What?
So this is just the mentors weekly updates to the JJS staff that may be slightly different than DCFS.
All right, so I am the wrong guy for this job. Anyone want to take over?
So I'll take over. I was just picking on Nick. He didn't have a slide. This was my attempt at making Nick talk to us. So much like the weekly report that y'all would send to a DCFS case manager, if you've got a JJS involved youth, we would just want to make sure you're sending a weekly update to the case manager. And I had a hard time with the difference between caseworker and case manager, so I just wanted to point that out specifically. It's funny how your brain, once you see case, just fills in the next word and you don't even realize that it's a different word. So that took me a minute to realize. And then I also wanted to point out the community mentors are individuals that are typically assigned to the student in their proctor homes or in facilities. So that's just another individual that we might want to collaborate with if we've got JJS involved youth. So that's pretty much it on the weekly report. And this is one of the templates that CNC gives us. So if you guys need that, holler at me and I'll send it your way. Also, I wanted to make sure for April and Jackie, we talked about our directories. So on the state board website, on the YIC page, we have the 2 directories posted in 2 different places. So the ETCAs, which are the Educational Career Transition Associates, we've heard from them recently, their directory is posted on the directory tab, as well as where you'll find the YIC directors list. And then the Check and Connect mentors and other related staff directory is posted on the Utah Mentoring tab. And I've just tried to keep everything with mentors on the mentoring tab, and that's why there are directories over there. So I just wanted to point that out real quick. And I do have a hyperlink here for you at the bottom. And like April and Jackie, I'll go ahead and send these out as part of the follow-up. So,
Amanda, I have a quick question.
Please.
So for the Check and Connect mentors, are they listed on that directory throughout the state?
Yes, on the Check and Connect directory, we've got all of the districts broken down by individual districts with their mentor or their team of mentors listed.
Perfect. Okay, thank you.
You're welcome. So unless we have any other questions or information we want to share with each other, we get to end early today. I feel like we all get a prize because this is quite a bit earlier than we were anticipating ending today. So, but if we do have questions, we do definitely have time for a few here. So give you guys just a second if you want to unmute or put something in the chat before we call it a morning.
Amanda, can I get that link for the JJS form?
Yes, I will.
This is Amy Norton at Box Elder School District.
Okay, Amy, thank you. And that was something I said at the beginning of the meeting, but you reminded me, Amy. If you want verification of participation today, shoot me an email, especially if you signed in under iPhone or iPad or something like that. Send me an email so that I can verify your participation today. And that way you'll get the follow-up email that has the PDF of the PowerPoints and those hyperlinks in it.
Okay.
Thank you. Well, I don't see anything in the chat. Nor am I seeing anybody pop off mute. So I believe we are done with this morning's webinar. There is our post-training survey link on the screen. But like usual, I'll include that in the follow-up email so you can just click on it to access. And you're welcome to contact any of the presenters today if you have questions, or reach out to me, Nick, or Julia anytime. Thank you so much for joining us this morning, and have a